Almost after 152 years in existence, IPC Section 124A, also called as the Sedition Law, was put on hold by Supreme Court on 11th of May 2022. What is the Sedition Law and why is it so important in present day? Hello and welcome back to Raju Notes channel. Today we will see the history of Sedition Law under Section IPC 124A from 1870 to 2022 and know more details about it. The original drafting of IPC was done in 1837 under Thomas Macaulay and was brought into force in 1860. At that time, it had no sections concerning sedition, but through a clause of 113 of the draft IPC, he introduced sedition as an offence punishable with life imprisonment. However, it argued that the clause on sedition was dropped from the original IPC draft was by mistake. In 1870, James Fitzjames Stephen, a British politician and lawyer, introduced Section 124A in the colonial IPC. The British rulers used this law to muzzle demands for freedom in India. Bal Gangadhar Tilak was the first person convicted under the sedition law for his speeches at the Shivaji festival. In 1922, Mohandas Karamchand Gandhi was charged with sedition due to his politically sensitive articles in Young India. Gandhi pleaded guilty and was convicted and sentenced to 6 years in jail, but later released after 2 years on medical grounds. In 1942, the Federal Court of India defined sedition law as a public disorder or a reasonable anticipation or likelihood of public disorder as per the definition, which is very controversial as of today. In 1949, after rounds of argument, sedition was no longer part of the Indian Constitution adopted on 26 November as grounds for reasonable restrictions for fundamental freedom. However, the Section 124A remained in IPC. In 1951, the Nehru government brought the first amendment under Article 19(1)A and puts reasonable restrictions on the right to free speech. In 1974, Indira Gandhi government made Section 124A a cognizable offence that authorized police to make arrests without any warrant. In 2021, a sedition law was challenged by various representatives of and a notice was issued by Supreme Court asking for a reply from the central government. In 2022, the Supreme Court declared to hold a final hearing on the pleas and the centre was given time to clear its stand on scrapping this draconian law. Accordingly, the centre gave its agreement and 9th May 22, the centre tells the Supreme Court that they will re-examine and reconsider the provisions of Section 124A of the IPC, and on 11th May 2022, Supreme Court allowed the centre to rethink and re-examine the Section 124A. Till then, no new cases to be booked and those currently in jail under the law can apply for the bail as per the Supreme Court's order. Let's quickly see some of the landmark judgments. The first sedition case of India was between Queen Empress and Jogendra Chandra Bose and others in Calcutta High Court. The manager, printer and the editor of the Bengali magazine Bongo Basi were tried for sedition as they had criticized the British government for raising the age of consent for sexual intercourse. The second was of the Kedarnath versus State of Bihar. In 1962, a 7-judge bench of Supreme Court upheld the validity of Section 124A, wherein Justice B.P. Sinha clarified that unless there is an incitement or call for violence, it does not fall under sedition. And the last one was the Balwant Singh versus the state of Punjab. In 1995, Balwant Singh, accused of raising Khalistani slogans after an assassination of Prime Minister Indira Gandhi, Supreme Court acquits Singh, stating that casually raising slogans without any violence resulting from them does not amount to sedition. So 3 cases, 3 different types. Likewise, many cases the sedition law has been twisted and used as per the convenience of the government. So let's see what comes out of this entire exercise, what the Supreme Court has ordered and what the central government is also planning to do. Thank you so much for listening to me. If you are listening to me for the first time or time and again,